Okay, welcome Bill Walker, a new member of our board of directors. Bill has been a wealth of information for our group, and his depth of experience is staggering. He was a co-founder of FOAVC, Friends of Article 5 Convention, who were recently mentioned in the Congressional Research Service report in 2012, and they were referred to as perhaps the leading proponent of an Article 5 convention. It is our honor to have Bill join us here today. Welcome, Bill. Aloha.
Hi, how are you?
Very good. First, before we begin, I'd like to inform everybody who might not be clear about Article 5 of the Constitution. It says, and I'm going to paraphrase here, the Congress, on the application of the legislatures of two-thirds of the several states, shall call a convention for proposing amendments. Now, you've been working on the Article 5 convention effort to trigger a convention for quite some time now. Um, how many states have already bothered to apply for a convention? Um,
40,
excuse me?
49.
49. Two-thirds of the states is 34 states, so 49, that's almost all of the states. The only state that hasn't applied,
Hawaii.
Hawaii. Actually, that's my state. It's odd that we haven't applied yet, so we've got to kind of get busy on that. Apparently, although if we've already got 49 states, it doesn't seem like we need to, but it is a nice round
It would
number.
be nice. It would be able to nice though to say a nice round 50 states, rather than 49. It
We can
just
make it unanimous.
yes.
um, now, how many applications have there been total from for these 49 different states? Have they all applied just once or twice, or how many times have they tried to do this?
Well, if memory serves, the highest number of applications from a single state, I believe, is 17 from the state of Indiana.
Wow.
And total number now, you have to understand that Congress has not kept good records regarding applications. So it's very difficult to give you an exact figure because the records are not kept so that you can compare what's submitted to the House of Representatives versus what's printed in the Senate side of the Congressional Record, which is where all the applications throughout history have been submitted. And there's no timeline. In other words, something that's sent by the states in March might not be published until December. In the Senate, you might not see it referred to, and then only by a passing remark in October in the House. So without the text to compare, you basically just have to add up everything and say, this is the total number that's facing Congress. You have right now, as near as we can determine, about 746 applications from 49 states. Some of these have never been verified. They are from reference books of authors that have written in the past. We have only published those applications that are actually in the congressional record. Some sources publish what's sent in the states and so on and so forth. But as you already pointed out, it states very clearly on the application of its two-thirds of the state legislatures, Congress shall. So in other words, the application to count has to go to Congress. So the fact that it's a state record doesn't mean that it necessarily was submitted for whatever reason, particularly in the olden 1800 or early 1900s, for example. So we have only counted the applications that have shown up in the actual congressional record. So most likely the number that we say when we say 746 probably is cut in half, because when you take the one that says in the House where they don't give the text and take it with the Senate one, if you could compare the two texts, you'd have to put them together. So the actual number is anywhere from 10 to 20 times the number necessary to cause a convention call.
Wow. Wow. That's quite a ratio. Now, you're talking about that you actually found these records in the congressional record. Your group, Friends of Article 5 Convention, took on the task of actually compiling the first database of all these applications into one giant list that we can all review. And before that, was there any kind of list? How did you end up going down this road? Can you? explain that
Yeah,
story?
there has been there have been several researches done from people who have written books uh, clear back in the 50s. But the trouble is, they've either cited them by name or they've just given the title of it. Nobody had ever actually published the actual applications, the actual text of these applications. And a lot of people didn't believe it. They didn't do it, and so on and so forth. So for various reasons, yeah, we went to the actual text and we tried as best we could to show the entire page of the Congressional Record, so that if anybody says, well, you're faking it, our response has always been the same, and no one has actually ever refuted it. We say, well, knock yourself out. Go down to the public library, find the volume, pull it to the page, and read it. It's right there. It's public record. And so we don't just show the application. Some cases we have no choice. That's just what was available.
Right.
And in some cases, especially later with the electronic stuff, we have been forced to use PDF files of printouts from Thomas rather than the actual page, because that's just the way that Thomas worked in some cases. But where we've actually had a photographic copy from a research agency or research group that we hired, and they went in and went page by page by page. Now, they used a reference to start out with from a gentleman known as Lynn Bowie and Justice Van Sickle. It was written in the Hamlin Law Review in the 1990s. That's where we started. Hamlin, that particular one, showed 567 applications. If you go back even further, in the 1973, you go to the ABA report which examined various ideas and concepts about it, and they had over 300. Now, the interesting point about this is that always been an argument of how do you count these applications. And we have held, as the Supreme Court has, as the Congress has, in historic records, as the founders had, that it's just strictly numeric count of, states. How do you have 2/3 of the same subject, for example?
Right.
So it's a straight numeric count. The ABA report said, well, it's the same subject, got to have them all for the same subject. Well, first of all, in the historic record of the convention, that idea specifically, the states proposing an amendment, was turned down, specifically, expressly, textually. Isn't it the assumption it's an actual voted record that we have? So the question then becomes, okay, well, how do you count these applications as a numeric set? Well, basically 1, 2, 3, 4, 5, 6, 7, 8, because the founders said that it was peremptory. They said that there was no vote in Congress, there was no debate, there is no committee. Well, go ahead and try to determine the same subject between two applications if you can't debate or vote on it. Right. It's impossible. So it pretty well lays itself out. And we wanted the text to be read by people because we wanted people to finally be able to say, well, we don't believe there's that many. Well, here they are. Check it out yourself. Go to the library. Go to online.
Right.
And people have responded.
Now,
and
I think it's also important to note, when was that database put together? What year did you folks release that publicly?
FOAVC was founded in February of 2007. A lot of people started asking us for it that year. We got started on it in earnest in about January 2008, and it's been an ongoing process since then. Most of the list was substantially gathered by about 2010. They went in and they found that. And of course, the thing was, the original 567, like I said, has grown now to over 740. So, I mean, not only would we confirm Bowie's and the ABA, which said there was 300 same subject. By the way, this is an important point I should have made about that. The ABA report said that it was same subject. Their own figures showed that at least two subjects, repeal of income tax and apportionment, had reached their 2/3 mark, and then they said, well, it's just no for you. You can't count it. Well, either it is or it isn't,
right.
And so, and by the way, it was. We've got had to validate it. So your point being is that your applications with the text, you can now see it yourself. You want to argue that whether this is for such and so, well, then look at the text. Read it yourself. You want to repeal of federal income tax? Well, here it is. The text says that repeal of federal income tax. Well, it's pretty hard. Or repeal the 16th Amendment, or whatever. It's going to be pretty hard to refute that as saying it's not an application for X. But the point everybody misses on this, and this is where they foul up, is they assume Congress has to decide this same subject. No, this is for a convention to discuss, to propose, to
Right.
argue, to debate. So anything that's in there as far as content, agenda, so on and so forth, that's for the convention to be dealing with. The only thing Congress is constitutionally required to do is make sure that 2/3 of the states have applied for it. They could just as easily be asking for pistachio nuts to become the national nut in 34 applications, and they'd still have to call.
Right.
But the point is that where the people don't understand is that the states can't propose, but they dispose. They take care of this as whether it's going to be in the Constitution, because in one form or another, the states have to ratify whatever a convention or Congress proposes. So there, the subject matter then is reviewable by somebody. And if they don't propose, they just don't support it, and it's not ratified. If it's not ratified, it doesn't come back. If it's actually voted down by the states by enough numbers, it's gone.
Amazing.
So there's hidden back agendas.
Kind of a gamble then, too, actually. Right. Now, actually, I want to skip to 2011 when you attended a convention, a conference at Harvard for the Constitutional Convention, Constitutional Convention Conference, Con, I think it was called. And you had a short speech. It was about 6 to 10 minutes, I think. And considering the depth of experience and whatnot that you've had, it seemed that your time was cut short in a lot of ways. And I've always kind of wondered, with all of these brainy people all together at once, with a chance to compare notes and everything, did it seem like, was there something that you wanted to talk about more at that conference that really wasn't brought up? And if you had the chance to really explore some things with these people, what would it have been?
But the thing was that I have to say that the 3 minutes, I think, got most of my points across that I would have made. Basically, I was attacking all of the myths and misunderstandings which is what I would have done on Sunday if I'd elected to go that way. But like I said, I wanted as much exposure as possible, because the big issue still, but a lot less today, and I think it started at Harvard, was that I think my speech basically broke this idea of a convention being a runaway and dangerous and so on and so forth. I also think that we have won a major victory, FOAVC is that practically nobody except maybe John Birch's diehards calls it a constitutional convention any longer. Right. They all call it an Article 5 convention. The nomenclature is now accurate, if nothing else. And because it's an Article 5 convention, people like the opponents and John Birch are having a real problem now, because everybody is starting to say Article 5 convention, and they're breaking it apart from what they were thinking that it was a constitutional convention, and they are two separate things. The Constitutional Convention's illegal, unconstitutional. Article 5 convention proposes amendments limited to that purpose and is constitutional. So that whole speech, I think I got the points across. I would have liked to have given the 30-minute speech, give more details. But I pointed out to people in that speech, which I called the truth, that they already had all the information. And I just went down through it. I said, okay, this is what we already know. This is what we know. This is what we know. This is what we know. And by the time I got done, there just wasn't any reason not to call. And I think that hit a lot of people. They hadn't realized, and say, look, the 14th Amendment says you're going to have equal protection. Okay, equal protection means the election laws are going to be the same. So you're going to vote them. You're going to elect them just like a member of Congress. Equal protection says that you got to do 2/3 vote, and so on and so forth, and so on and so forth.
Right. Now, the Congressional Research Service in the report said, and I'm going to quote here, with well over a century of experience of proposing an Article 5 convention, the states have arrived at a certain precedent for consideration of these applications. And we submitted that, quote, with a letter and request, and you helped us out with that letter that we submitted to the Clerk of the House of Representatives. I have to thank you for your input on that as well. if they decide, and we can't understand how they would avoid it, but when they consider these applications, what do you think the answer is going to be? What do you think that they're going to determine?
Well, that's the point of the whole thing. They have nothing. They know constitutionally they can't. There's nothing for them to determine. They got to count to 34. That's it. When they reach 34th state, they got to call. There is no consideration of the application. There is no thing. And this is not my opinion. This is the opinion of James Madison, who wrote Article 5. And he stated it in Congress in the House of Representatives, which is a very key point. This is an action by the House of Representatives. So they're going to have to refute their own decision. And they have never done that before. So this was an action in the House, in the Congress, not in the convention. This was stated in the House. So determination, they don't have any. They're not supposed to have. Because the whole idea of this concept that they came up with, this dual way to propose, was to make sure that neither side could control the other, so that if the states wanted to get something in the Constitution, there was a way they could do it. If the Congress wanted to propose something, there was a way it could do it, and they were independent of each other. And the idea was, and still is a viable idea, that this also acted, to use a modern phrase, like a 600-pound gorilla. Congress has the ability to propose. If it convinces the states, it can do something to regulate the states. The states have a way to be able to get in and get a convention. The convention proposes. And again, you have this 600-pound gorilla sitting, controlling, and balancing. It's literally balancing the Constitution as the rest of it. That's what the system of checks and balances is. The convention is a check and balance on the federal government that people just don't conceive that it's designed not to allow Congress to have anything to say about it, because otherwise it just becomes a subcommittee of Congress, and that is completely ridiculous. This is why the Supreme Court has stated numerous times that if there's 2/3 of the states, they've got to call. And they've never gone in and then put a lot of hysterics behind and say, unless Congress finds the wrong subject, or Congress is not in the right mood, or anything like that. It's just they got to call. And this is why, because it's fundamental to the system, that the way that the system is organized is so that you have a independent system to be able to amend and control the Constitution, so nobody really controls it, unless by consensus they do so. Right. In other words, the ratification process is your consensus, and the Congress has its own independent way to do it. So if you allow that they can control both sides, you've done why the founders got rid of that. They had it where states were going to propose amendments. They got rid of that, and they said, well, we'll have it both go through Congress. We'll have either states propose or Congress itself. And they said no, because Congress couldn't refuse to do it. So they made two separate systems.
Right. And George Washington also commented in his farewell speech, too, that the Constitution can only be changed by an explicit act of a whole people, not just one side of the political spectrum. It has to meet somewhere in the middle, and I completely agree with that. The more you examine the process, especially in ratification, some things that might squeak through a convention will potentially fall apart in ratification, just like if they came from Congress. And I think that the system was made like that to protect us. It's a fail-safe. It's not really a check and balance. It's our safety valve, basically.
Yeah, it's multiple layer. There's more than just the ratification in the Constitution to protect your amendment process. For example, the Congress is not allowed to legislate in Article 5, or specifically by terms of Article 1, the foregoing clause of the necessary and proper clause. People say, well, they can do that. Well, that was knocked out when the first ruling on the amendment process was Hollingsworth v. Virginia, 1798, and the Supreme Court just basically said the president cannot have any part of the amendatory process. Well, if you can't have the president involved, you can't legislate. And there was no debate about this. There was no, they were stating something that people fail to realize, just how much debate went into creating the Constitution. It wasn't like, the convention set it out on Monday and Tuesday we had a new Constitution. This thing was a battle royal for like 3 years. Every aspect of that Constitution was gone over. And there's no record anybody's ever found of there's even a question that the president could be involved in the amendment process. Nobody even questioned it. It was just, yeah, it's not going to be involved. No opposition, nobody talking about nothing. We just understood he's not part of that amendment process because, again, Congress could then legislate, control both sides, which is, again, why it's a peremptory on them. They can't debate, can't vote, and can't turn to a committee. So the whole thing makes logical sense if you just think about it for a minute,
Right.
And understand the objective: two independent amendment proposal systems.
Well, once again, I want to say thanks to Bill for joining us here today. I hope we have a lot more discussions coming up. Once again, you're such a wealth of knowledge and experience that you're like the shaman we have to keep checking in with every once in a while to see how things have gone over the past and kind of compare where we're going. So once again, thanks a lot for joining us and sharing your views with us.
Appreciate it.
And
Sure.
we'll be checking back with you again soon. Aloha.
Okay. Thank you.